that. So, okie dokie. Right, so we've got that on. So welcome everybody. Thank you very much indeed for coming along today. We deliberately chose today's date for a reason, and that was the 6th anniversary of Grenfell, which I'm sure has not escaped anybody on this call. And it just seemed fitting to actually take a quick look now at what's happened in those 6 years since the Grenfell tragedy. What has actually changed? How are we doing? What could we do better? There's been a lot of talk, there's been some action, and I'm sure we'll all have different views on how effective that action's been, depending on our where we're coming from as we discuss this. So the plan today really is to go through and discuss these different issues around the sort of the structure, and sort of take the pulse of where everybody is. If anything earth-shattering comes out of the conversation, then we can write that up and we can actually go into a bit more detail, or we can put something out in the press, or whatever it is, depending on the insights. And I can see a really great sort of mix of different skills and experience here on the course. That's fantastic. So thank you for coming. We obviously do want to remember and reflect Grenfell and be respectful of everybody that's been impacted by that tragedy as we speak today. So I think if we can just bear that in mind, that would be fantastic. So quick intros. So I'm chairing the panel today. So I run an organisation called Track My Risks, which is a software business that manages governance, risk and compliance. So one of our key areas of business is in building safety and golden thread activity. My background before going into risk management and managing software around risk back in the day was in construction and project management. So for my sins, I used to be a house builder. Thankfully didn't build too many blocks of high-rise flats, worked on a few, but mainly it was housing. But for one of the companies that comes up in these sorts of conversations very often, and has got some very high profile issues itself. The other part of what we do is the Building Safety Register, which is branding this talk today, which is very much around the base registration of high-rise buildings and how that now links into the Fire Safety England regs and the Building Safety Act. This started life in 2019 as effectively as an example of how the regulator could use our software platform to organise itself and start understanding the stock of high-rise buildings. I'll probably talk about it later, but let's just say the powers that be are very closed to having any kind of conversation about digital technology. So it's become a thing in its own right, and is a way of actually making sure that the right information is being collated about the correct buildings, so we can actually understand how big this problem is and how it links to regulators, but we'll come on to that. I'll introduce you to the panel. Unfortunately, unless he turns up, John Davis won't be joining us because he's been called to a site with an incident about 25 minutes ago, has gone to assess it, and then is understanding, he's going to do his best to join us. So hopefully John will join at some point. He may not. So if I hand over to my other panel members, so Emily Harbottle first.
Hi, everybody. Sorry, my computer's just wobbling. Hi, really pleased to be invited along by Matt today. So my background is in military aviation primarily, but a lot of safety background. So I flew helicopters, but then I worked for the regulator, so the Military Aviation Authority. And in defence, we were part of a big shift in culture, similar to what the building industry is going through now, back in 2009, following a very serious incident in Afghanistan with a Nimrod aircraft that proved to just be nothing related to the enemy, sadly, but all about decades of mismanagement of aircraft. And it came to light that actually there were fundamental systemic issues in the way safety was managed within defence aviation, the outcome of which was the introduction of a safety case regime. So there's so many parallels to what's happening, and I'm able to draw on my experience of writing safety cases and then regulating safety cases on both sides from my time in defence. Since then, I've worked a lot in civil aviation in different sectors, all around safety management systems, bow tie risk management. So yeah, I'm here today to give a layperson's perspective, though, on safety cases. What is a safety case? What should be in a safety case? How might you structure it into your sector? So thanks for having me. I think Deepa.
Hi everybody. Thank you, Matt, for inviting me to this today. I am Deepa Mistry. I'm a resident and building safety campaigner. I am a leaseholder and a shared owner living in a housing association property in London. My journey sort of began when the Grenfell tragedy happened and scaffolding went up on my building. It was very quickly assessed that we had the same ACM cladding as at Grenfell, and work was undertaken to remediate the block. So when that was done, I suppose it must have taken about a year. So by the time we got to mid 2018, I was hoping we would be in a position to be able to sell the property, because I have a family of 3 children, and it was probably not really appropriate to our needs. So it's taken us up to now. We're now 6 years later, and though the property has been remediated, I'm still awaiting all of the certification, the documentation that I require to be able to sell, and where it's certainly taken its toll on our life and, you know, stress levels with the family. We have subletted the property for the meantime and have moved temporarily to Leicester, which is where my family are. And I guess I am waiting very patiently on when this property is able to sell and does actually complete, and I can then rest easy and move on with our lives. So that's me.
Helpful to turn my microphone on. So thank you very much, Deepa. Thanks, Emily. John, if he does turn up, I'll just explain. He, as it says on the tin, head of building safety at Lewisham Homes. We've been working with John, as has Emily, on their safety case regime for some time now. And John is one of the early adopter group on safety cases. And for most of you, probably would have seen him sharing his thoughts on LinkedIn, as he's another one of the ones that doesn't necessarily keep quiet about some of the issues that are going on. So hopefully enough on him, but yeah, hopefully he'll join us a bit later. So just a few reminders, and I think I as I was looking into this, I thought, well, okay, it's 72 months, 6 years, 72 months, one for every life lost at Grenfell. When we start looking at the number of weeks of effort, 312 weeks, 52,500 hours since the tragedy, it strikes me that we should probably be further forward than we are in terms of progress. Probably not helped by the fact that we've had 4 prime ministers and 10 housing ministers. I couldn't actually easily work out the number of secretaries of state that we've had. I think it's slightly smaller than the 10, maybe 4 or 5 in that period, but these are actually the housing ministers with the responsibility for that brief. So it's not surprising, given that political backdrop, that there's an opportunity for things to be missed. We've had the independent review of building regulations and fire safety, so what was called the Hackett report or Hackett review, in 2018. We've also had, as most of you have seen, the Grenfell public inquiry, which went on for years, has now finished in the sense of taking evidence, but still hasn't delivered its final recommendations or its phase 2 recommendations. That will probably be, as I understand it, autumn this year as the timetable for that. We've got the building safety crisis, of which Deepa's block is one. There aren't any real numbers or reliable numbers in terms of how many blocks are impacted, but if we look just purely at the building safety fund for high-rise blocks, there were just over 2,000 blocks that applied for remediation funding. Not all of them were successful, and quite a few of them are stuck in the process. So I would say that the 3,000 blocks impacted number is probably a significant underestimate of the overall number across all low, medium and high rise. We then had the Fire Safety England regulations, which we'll come on to in more detail, in terms of the regulatory reform fire safety order clarification and the Home Office response to Grenfell coming from the public inquiry recommendations. And then we have the Department for Levelling Up response, which is the Building Safety Act 2022, which hasn't commenced yet. So quite a lot of response and a lot of activity, and we'll go into more detail about it. And then in terms of the panel discussion that we're going to go through is look at really what I want to talk about and speak to you guys on the call about is what's changed, how are we doing against that, what's actually making a difference. So what are the things that are making a huge difference, what are the things that sound good but haven't really had much impact. From a legal perspective, cultural change perspective, mainly within the industry, I think the culture in the industry and residents, and then the actual impact on resident safety. So have there been any items that have just given us a really big step forward in terms of resident safety, as opposed to just more paperwork? That'd be really interesting to explore. So some of the impacts, criminal proceedings. I know you'll see from the sort of the justice piece for the bereaved survivors and residents of Grenfell that there has been no justice in terms of criminal justice. That, to my understanding, is timetabled for the after the inquiry reports. So we would expect to see something happening in that regard formally sort of after October time. Whether there will be any criminal charges, who knows? I think a lot of people have been interviewed under caution. Where that's going to get to, what the health and safety executive are going to do, what the police are going to do, etc., is all yet to be seen. But the fact remains that criminal charges haven't been forthcoming 6 years after the tragedy. So at what point will this actually go to court and come out of the other end with any kind of judgment? Who knows? Maybe 7, 8 years, we don't know. And if anybody has any ideas on that or thoughts, then without jeopardizing a legal case or without naming anybody, it would be good to get some feedback on that. Civil proceedings, so there has been a bit of movement. There was a settlement for 900 bereaved survivors and residents agreed in April. The BBC are reporting that's about £150 million, which breaks down to on average about £166,000 per claimant before legal costs. So it sounds like a lot of money, but I think it doesn't really seem like a lot to me as an average. But again, there's nothing I've seen in the public domain to say what the scale of award is to different types of impacted claimant. This doesn't extend to everybody that's brought court action. I think this was litigants across 14 legal firms, but there is other legal action going on as well. So this is the start of it, but at least there's been some kind of adjudication from a court back in April. And then the two bits of regulation or legal change, really the two key things. I mean, there are clarification regulations underneath the Building Safety Act, etc., which we can talk about, but the Fire Safety England regs primarily clarifying the regulatory reform fire safety order, and we'll come on to the doors and external walls, etc. And the Building Safety Act. There is quite a bit of overlap actually, and I've sort of broken it down into the registration of duty holders. Not a term always used, but effectively we've got the responsible person in the RRO, and we've got the principal accountable person and accountable persons in the Building Safety Act. In some cases, they will be the same people or same organisations. In other cases, they won't. Under the BSA now, we've also got the authorised representative, which in certain circumstances would also be the responsible person under the RRO. discuss, not great, different duty holder roles are approximately doing the same thing. We've got information retention and sharing duties in both of these. So if we lump that under the golden thread, keeping evidence that you've done something, and in certain cases sharing the evidence that you're doing something with other people, and then that splits down largely into the regulators, so the fire service, building safety regulator, and residents. So those duties to actually share information with residents or make information available to residents. Share is sort of the wrong term really, but make it available. And in certain circumstances, that's by default. You have to make this information available. In others, it's when it's requested and it can't be withheld. But effectively, we are moving to a regime where more information is going into the public domain, even to the point with the Building Safety Act now, where the key building information that's uploaded and AP information will be published to an open register of high-rise buildings or higher risk buildings. So again, quite a lot of information that you would have normally kept private is now by default going to become public. There will also be opportunities for information that you would like to keep, more detailed information that you would like to keep private, that residents will have a legal right to access. Once they've accessed it, there's probably nothing to stop them then putting that into the public domain. So effectively, the majority of this regime will and can operate in public. So there are security impacts associated with that. And then we've got the whole resident engagement piece. Again, within the Fire Safety England regs, it's not so much full-on resident engagement, but it is providing evacuation information, updating monthly equipment checks, making that available to residents, and explaining about the purposes of fire doors, etc. So there is a more of a requirement now to engage with your residents than you had before. And under the Building Safety Act, you've now got the full legal duty for resident engagement, and that is a part of your assessment criteria when you're called forward by the regulator to get a building assessment certificate. So there are, I think, key themes there. It's highly unfortunate that these two regimes weren't merged or blended better. Probably not helped by the fact that they sit within two different government departments. There is a bit of overlap behind the scenes, but really there is a lot of duplication going on here, especially when it comes to data, which we'll probably touch on in a little bit later on in the discussion. So are there any hands up at the moment about anything that we've covered so far? No. Right. Okay. Emily and Deepa, are there any things before we sort of get into the detail of those two acts? Is there anything that observations at this moment that you guys have got?
So mine would probably just to be around the accountable person. So my experience in defence, and it's much easier to define and much easier to enforce because you've got a hierarchical structure and the rank structure, and a bit like a school, I suppose. You can say, well, the headmaster is accountable, and in defence there are layers of duty holding. So there's this most senior duty holder, then the middle sort of operating, and then the delivery. But it works because that is an individual, and they have to sign to say, I accept the risk, that I am accountable for the risks associated with this particular activity. If that individual isn't willing to accept those risks, it is escalated to the next level, and eventually to Secretary of State for Defence. I suppose I struggle with the concept of a board or a management organisation being the principal accountable person, because the whole rationale, my understanding, is that a person has to put their name to it and say, yes, I think this is safe. It's a big ask, but it is also, that person is then accountable. That's the whole point. And it feels a little bit like going round in a circle, going back to where the industry was once before, where still not really a person who's going to be held to account. So I don't know if anybody has any challenges to me on that, or how they see that might work.
There is, well, somebody hopefully will jump in with that, especially those that are in that position. There is some consultation at the moment around that definition of the natural person versus the organisation, and I've forgotten the name of it at the moment, and I'm pretty sure it's still an open consultation. So I think that will end up in another regulation at some point fairly soon. Certainly my understanding through this as it was developed was that the whole point is to actually put human people that can go to prison in the frame, as opposed to organisations that can't. At the moment, I think with the registration process, it's an either or, but you do have to put a contact name in. But I think that's not quite the same as saying Emily Harbottle is the accountable person for building X, until such time as you novate that to somebody else. But has anybody got a bit more of an update on this? So Jan's got his hand up, so I can see.
I'm so firstly checking you, mate.
Yeah, we can hear you.
Yeah,
okay.
Yeah, you're all good, Jan.
It's all right. It's a bit weird sitting on your own, isn't it, in a room with just a screen. The regulator had a big in-person session in London a few months ago. 955 people were there, and there is a presentation that's available, I think, online from the building regulator that makes it quite clear that the accountable person is an organisation and not a person. They've made it quite clear, in my view, that it's the organisation. There has to be a named contact, but it's the organisation, not a person. And then we get back to the nonsense about the way it's defined in law. But that's my understanding. I'm happy to try and find the link to share it if I can. But that was my understanding of the situation, which is in direct conflict with what Emily understands, because that's what Emily understands is logic. But we're dealing with two different government departments here, and logic doesn't always flow. So that's the current situation. Happy to share it, and if anybody disagrees, then happy to step back. But that's my understanding.
I think Peter wants to say something. So Peter Waxman, if you can come off mute. Peter, can you?
Otherwise, I was just
Peter,
going to.
you will need to unmute yourself because we can't unmute you, I'm afraid.
Just while we're waiting for Peter, I was going to say, so Simon Collery's put a comment saying the risk of going to prison is hardly going to encourage anyone to agree to be that person. Yeah, totally agree. And when that first came into defence, there was massive pushback saying, well, I don't want to have to go to court or be standing in the dock. But it ties into the safety case regime and the shift in culture that we saw and we will see, in that if you have a good safety case, it is your legal case. That building may not be 100% safe in every respect. Probably no building can be, but people still have to live in it. So it's this taking a balanced view. Have we taken all reasonable steps? Is it proportionate to do anything else? Am I content that actually it is where I need it to be in terms of the safety of the building? And that is why the safety case is so important, to be able to back up the person who's making that accountability statement to say, look, I based my statement of the safety of that building on this safety case. And that's why it can't just be a one-off report. It's a live, ongoing thing that the principle, the accountable people have to be involved in, have to really get stuck into as well, because that is your, like a legal case, that is your evidence to say why you made that decision. And things are always going to happen, but if you can turn around and say, well, look, we did everything, and here is everything to prove that we did everything we could, this was an unforeseeable event or whatever, that you then have the fallback. If you don't have the safety case, you can't have an accountable person, I don't think. So, Peter, you wanted to say that individuals may be prosecuted under the Corporate Manslaughter Act?
I think I will. Unfortunately, I can't look at it at the moment, but I will look and try and report back on where this potential rollback has come from in terms of that personal responsibility, because that wasn't the way that it was recommended by.
Yeah, Mark, Mark, have you got your hand up? Can you unmute yourself? Are you able to do that? There we go.
Yes, I think so. Yeah, can you hear me?
Yeah.
Yeah. So yeah, the Building Safety Conference or Regulator Conference actually was clear on that the it's not something that can be assigned, like the accountable person or principal accountable person can't be assigned to someone to carry out. But it does say that they did say that an accountable person will not be either an organisation or an individual. So I agree with Jan in that respect. And an organisation or individual required under the terms of a lease or by virtue of an enactment, and I'm reading here from the slides that I've got from the BSR, to repair or maintain any part of the common parts of a building. So it is an organisation or an individual. They're under the sort of registration, an individual does need to be named, but it doesn't mean that they are the accountable person or the principal accountable person. So they're terming organisations, and they gave a bullet points. They termed organisations that they could be a local authority or social housing provider, a resident management company, a common hold association, or a right to manage company. So they have defined that, and I suppose for me, the way the regulation or the approach that the new regime is trying to take is that, you know, you need to evidence and demonstrate that you've undertaken all that is necessary and reasonably practicable, I think it is, or reasonable measures that goes beyond kind of the reasonable skill and care clause that we normally see. It goes further to demonstrate that you are applying the building safety principles within your organisation, and that will go down to evidence-based information such as the golden thread.
Yeah, we'll come on to that, Mark. But
it's making sure that you've got your quality management process in place to back up your attestation that you are managing your buildings safely.
Thank you.
So I just wanted to quickly say, sorry, I'm wired for sound now. Yeah, I've never really got the hang of it, because if you look at L153, the CDM HSC document, it says the duty holder can be an individual or an organisation, and yeah, I just never got to the bottom of that really, and yeah, I agree with Emily's comment. Yeah, thanks.
Review. Thank you. Right, so moving on. Really great questions and impact. Thank you, or insight. So the first thing that happened in terms of regulatory response, Fire Safety England regs. So we got very excited about those. They commenced in January 2023. And so this is really the clarification of the regulatory reform fire safety order, specifically talking about, amongst other things, external walls and fire doors of being explicitly within the scope of the order when it comes to residential buildings. The need for fire door inspections, monthly equipment inspections, again, of the 7 key fire and life safety pieces of equipment that you might have in any given building, sharing certain information with the fire and rescue services. So again, site building plan and unique floor plans, simplified plans for sharing with crews. The provision of information to residents in terms of the outcome of those monthly inspections, in terms of evacuation information, and the purpose of fire doors and the renewal of that information on an annual basis, and for new people moving in, new residents moving in, which all seems sort of very sensible response to the that came from the Grenfell inquiry. Fault reporting, so when those monthly equipment inspections take place, if they're in fault for more than 24 hours, then that's a reporting duty to the local fire service. And it all seemed to me very sensible. I've got a screenshot there of the little sort of Ready Reckoner tool where you can change the height of the building, and it tells you in broad terms what the duties are. it's all been a bit of a damp squib, really. Weirdly, bearing in mind this was sort of the first proper legal power change after Grenfell, my observation would be that the fire services weren't ready for the change, especially when it comes to taking in information from responsible persons. A lot of responsible persons weren't ready to provide that information. The fire services weren't given any systems or budget to manage this increased regulatory scope. It wasn't really promoted widely, so still to the point now, if obviously Deepa and I were chatting about it prior to this call, and it was kind of news to her as a resident that she's got some more rights now than she had before. So it's been I think the way I would describe it is a bit sort of half-assed, really. And somebody actually from America described this on one of my posts as ceremonial regulation. So a regulation that's implemented when people don't actually care but want to be seen to be doing something. Now, maybe that's a bit harsh, but it hasn't, from what I've seen, created this sort of the cultural change in terms of the way buildings are managed that I was expecting it to. I don't know, Deepa, did you want to mention something about, I've probably stolen your thunder, but about what you've seen from a resident's perspective about all of this?
Yes, I can jump in here. I actually have received a building safety record for my block from the Housing Association. This was dated October of last year, so it looks like it was done before the regulations came into force, which is good news. It's a little unclear what they're covering in here, and I know from your Ready Reckoner there are a few items where results need to be shared with the residents. For example, the recording the monthly lift and firefighting equipment. I don't seem to have a record of that. So this sort of information I haven't been receiving, but I have had at least a basic building safety record. So I'm just going through it. I've got information on the construction and the cladding type. I've got information on the fire evacuation strategy. I've got data on what fire safety measures are in the home, like the smoke ventilation system, the heat detector, that sort of thing. There's information on the front doors, which is really good, but it does say it needs checking annually. However, I haven't seen an annual report to say that has been done. There's some information on, basic fire safety, don't have a barbecue inside, that kind of thing. And then I have a list of, I have a list of checks that need to be done on a regular basis. This is, I guess this is setting up for the Housing Association to provide me with the information, but I've not heard anything about this since. So that's, the FRA, the lifts being inspected every month, the gas safety being checked, the wiring being checked, the fire hydrant being tested, fire detection system being tested, that sort of thing. It's listed here. So it's great that this has been communicated, but in actual fact, I think what it means for me has not been communicated. So that's where I really would have appreciated, say, my neighbourhood manager to come and meet with the residents and say, look, these are the checks that we've done. This is what it means to you. And this is how often we're going to provide you with this information. And if there is anything to worry about, then we will obviously let you know. I haven't actually met my neighbourhood manager for about 5 years, I believe. And I do believe that the manager has changed. So when they get round to coming to a building, obviously we will have this conversation, but unless I take the initiative to have that conversation with the Housing Association, I don't expect that it's going to be forthcoming.
I think it to my mind, that if residents understand what these systems do and how they keep them safe, what they mean, how they work with each other, what they're called, I think this harks back to Grenfell, then you're more likely to get that feedback back that says, hang on a minute, that thing that I understand, I can't remember the name of it, but it's really important, is hanging off the wall. And that's reported as a fault, and then that fault's dealt with, and we're overall, between us, we're going to keep everyone safer than they would have been if we'd left it hanging off the wall for 6 months, just simply. So what would be really interesting, I think, is if you understand what this is then the evidence which the Fire Safety England reg should show you, which is that these things are actually being tested every month, a bit like the sort of the, this toilet was last checked at this date and time by this person register, which could be in a prominent place. Is there anyone else in the attending that has got a view on that, that's involved in managing this compliance, and what the challenges have been with the rollout of the FSCR?
Hi.
Gotcha.
I'm not directly involved in managing anything at the moment, but I'm aware of a number of people who are spending a large amount of their time actually doing that very thing. I would say that of course the main information about regulations for information to residents doesn't come into force until the 1st of October, which is part of the Building Safety Act Clause 156. So it may well be that people are trying to get their act together in preparation for that change in the legislation. The other issue, of course, for Deepa is in a block where she's a shared owner and a leaseholder as to who, it's not for to now, but there may well be an issue about who actually owns the door that is attached to her property, which may be an issue for the landlord. But to say that, but the fact that she's not seen anybody for 5 years is not good, and I would suggest a letter to contact to the organisation to try and put that right immediately. But certainly I'm aware that there's a great deal of activity from a managerial perspective, with a range of social landlords doing a great deal of work around this. One of their challenges is that none of the fire and rescue services have an identical form of reporting. So for a housing organisation that's got properties in 30 different locations in the country, they're having to produce information in 30 different ways, which obviously is part of that point that you made, Matt, at the very beginning, where the rules have changed, but the fire and rescue services weren't actually given the resources or the wherewithal to put it into place in the first place, which may well be why the fire and rescue services haven't been quite so quick to do anything about it, because they're still struggling to deal with the information they're currently receiving.
Yeah, and you're right. I mean, this is the key point why I said it at the start. If you took someone like LFB, the LFB, and said, okay, you've got approximately 6,000 or 7,000 high-rise buildings in the London Fire Brigade area, the last I heard. So that if there's 3 or 4 unique floors plus a building, so that's 5 floor plans that they need to ingest times 7,000 that they need to receive in from various responsible persons. They don't have a definitive list of where all these buildings are or who manages them, because they'll start getting that when they get the information. And then if they've got monthly fault reporting coming in, so 7 areas times 7,000, but then with a corresponding rectification at some point and tracking dates, it doesn't take the brains of a rocket scientist to realize that that's a lot of moving parts now that they were ignorant of prior to the Fire Safety England regs being implemented. So you're correct that each of the fire services has gone away to try to solve that problem on their own. And then some of them said, well, we can't do it. So the NFCC jumped in and said, okay, well, we'll create a Google form for you, and then you can just slap your logo on it. Quite what happens to that data if and when it lands within a fire service is anybody's guess. Just as I was preparing for this, I went and had a look and sort of said, well, okay, has anybody actually written anything as a retrospective, sort of 4 or 5 months into the Fire Safety England regs, what's happened, what's changed, how's it gone, has anybody been enforced against, and it is spectacularly bare on Google. That it just hasn't been spoken about. It's just that the regulation that shall not be mentioned. At the Building Safety Regulator Conference, I did have a chat with the chap from the Home Office that's responsible for the policy, and it almost came across that he was just sort of happy that he ticked the box and got it across the line and it was live. There wasn't really much interest in discussing how do we use this regulation to make people safe. So I don't know, we will see, and it may well be that yes, there's a bit more of a delay waiting for the 1st of October date, which we'll come on to. So probably time to move on. But are there any, just before I move on, are there any sorry, hands up.
Deepa's been waiting.
Oh, Deepa, sorry.
Oh, that's okay. I know that Dean's making some comments as well. Do you want me to read them out?
No, it's okay. Is there a summary?
Well, I wanted to respond to Jan. So Jan, yes, I will be writing to the Housing Association to work out where our communication is going to hopefully improve and where we get to meet the neighbourhood manager. But what I wanted to add to that was when I first moved into the block, it's now 13 years ago. Within the first, say, 3 or 4 years, there was quite a decent level of interaction. So there was two-way communication between myself and the neighbourhood manager, and we all spoke to each other because they walked around once every month. So I knew when it would be, and I knew that I would be able to catch them and have a chat if anything needed doing. However, I believe it's since Grenfell has happened, and that's when I noticed the difference, that there was a bit of a step back in engagement and in communication. And I don't know whether that's due to a fear of, what's the resident going to say and how much are you going to have to listen to, or whether it's just a change in culture. But I do believe that over the 13 years I've lived there, that's not the only thing that's impacted. It's also the size of the organisation. We have, well, not we, the Housing Association has grown enormously, and I don't believe that the infrastructure is there to be able to manage and to be able to engage with residents in the way that they initially were, or in my initial experience. So I believe that there's a number of things that have compounded to this level of a resident feeling, well, I don't really know what's going on, and where do I stand, or what do I do if I need to speak to somebody, particularly when a lot of services have been automated and you need to call through to a call centre, which then takes potentially 48 hours, 72 hours. It could be even longer, depending on what it is to get a response. Yeah, that's what I wanted to add. But thank you, Jan.
Thanks, Deepa. I think there's there's 2 or 3 sides to every story, and I think from a housing association's perspective as well, is that Grenfell happened, all of a sudden resource gets sucked into what are on the walls of our buildings, what's happening with the regulatory change, what's the inquiry doing, what impact does that have on us, what does it do to our budgets, etc., etc. And I don't think there's been a corresponding allocation of huge amounts of money for extra people and systems to actually manage this change. So I think what we've got with these regulations is just add more and more to the pile, but I don't think anybody's actually looked from a government perspective to say, how are we going to manage this change and bring everybody with us across this journey whilst making everybody safer as well? So we're still at a point where we're waiting for guidance, and we'll actually come on to the Building Safety Act. I think this is what's causing a lot of the problem. That we all knew that the Hackett report had come out, the inquiry was ongoing, change was coming, etc., etc. But still today, bearing in mind we're less than 4 months away from commencement, lots of the regulation still isn't there. We still can't absolutely hand on heart define exactly what the accountable person is. We can't fully register a high risk building with the regulator yet, because they haven't turned on 80% of the registration journey. So it leads people to speculate. It's not clear, and sometime in the future it's sort of happening on top of us, but without the clarity. So just on the Building Safety Act, so I think this is the main change that I think everybody focuses on, and that's probably why the FSCR has sort of slid along under the radar, I think, and caught people by surprise. We have the Building Safety Regulator that's in the process of being enabled. I don't think it's got off to a flying start in terms of its ability to recruit, its ability to communicate, its ability to keep hold of a chief inspector of buildings, for whatever reason, which I think has sort of led to misunderstandings in the marketplace, and similarly probably hasn't helped the regulator to establish itself when it's then entirely dependent on government to formulate policy and law, and create an unbelievable amount of change within a very, very short period of time. You know, this is huge, and I do apologise now for the fact that most of this conversation and my thinking and expertise is in relation to the occupancy phase, so sort of gateway 3. Gateways 1 and 2, the sort of the planning gateways and construction, again, are a slightly different specialism, but in my head, not as difficult, because I've always asked the question of how do we manage this change 13,000 times with clarity and without burying everybody. And I think that's where the biggest, certainly where the risk sits, is in the occupied estate, and where a lot of the work sits. If we're thinking about bringing a new building out of the ground now, yeah, we might be having a debate about whether one staircase is acceptable, whether we need two, but we can. That's a desktop exercise. It's a delay. That's entirely different to, I've got a 1960s LPS 15-story block. Do I demolish it? Can I remediate it? Can I put forward a defensible safety case to the regulator? What do I do with all of these people? We haven't got any money. Do I spend it on damp and mold? Do I spend it on fire stopping? What do I do? So that's the challenge that we've got culturally as an industry, and technically, set against a backdrop of ambiguous regulation, which are deliberately ambiguous, because we'll come on to safety cases in a minute, that effectively there is no right answer. There is no compliance checklist to say that I've ticked 25 boxes, that's a safe building, or it's a compliant building, which is deliberate. So I want to go through the headings of what's going on in relation to the Building Safety Act. So with a commencement on the 1st of October this year, the first date, or one of the first key activities that we've got to do for every higher risk or high rise building, whatever you want to call it, is we've got to register it with the building safety regulator. So that registration opened on the 12th of April. The initial registration, where you can jump on and you can say, you know, I'm Fred Smith, I'm the accountable person for the building, and here's its UPRN and its address, etc., and you can pay them 251 quid as a registration fee. You can go in and do that multiple times for as many buildings as you have in your portfolio. You can only do that as individual one-to-one transactions. So one payment of £251, one unique building registration, and then you do building 2, you've got to put your credit card details in again, and you've got to put all of your contact details in again, and repeat for as many dozens or hundreds of buildings as you have in your portfolio. That registration portal does not see you as you with 100 buildings, it sees you 100 times in its data set. At some point, at the moment it's just tipped to be the summer, the regulator will open up the second stage of the registration process, which is the key building information upload, which is probably going to be 40 or 50 detailed questions about each of those individual buildings. Just to give the background of this, key building information, on the 6th of April, the government commenced the Higher Risk Buildings Key Building Information England regulations, and that sets out from the Secretary of State's perspective what information you would need to register. On the 17th of May, the government then put out government guidance about key building information registration. And there are differences, and some of them are quite material, between those two versions of events. The key issue in relation to that is around structural information, which is pretty important. So there are two questions in the regulations. One of them is around the materials used for the structure, so concrete or timber or steel frame or whatever, fairly easy to answer, I think, for most people. And then the second question is around the type of design used in accordance with, or not to comply with, that's wrong, so I haven't got it to read in front of me. The type of design used in relation to the building regulations 2010 Part A, structural requirements, etc. So it doesn't really make sense as a question, but that has disappeared from the guidance. So we're unclear at the moment, and the building safety regulator are refusing to answer what's happened to that question, because when I've asked clients of ours, how would you answer that question if I asked you that question, the first question back is, well, what does it mean? And when we debate what we think it might mean, it's then a question of saying, well, this is a 1960s LPS block. The 2010 regs didn't apply, so do I need to now retrospectively look at the design and say whether it would comply today? It's not a yes/no question in the way that it's phrased. If the question was, does this building comply with the building regs 2010, you could say yes, no, don't know. That's not the way it's phrased in the regs. So I've been chasing for quite a while now the regulator to actually publish their question set that they're planning to put live at some point in the future, with no response. If anyone has got an update on that and has got any definitive information that goes beyond that, that would be great to hear it and share it with the group. Put your hand up if you do. The other key point with registration, there's a couple of other key issues with registration. At the time of the Building Safety Regulator Conference, we were all of the opinion, or it became more sort of common knowledge, that there was a 28-day registration window. So from the point you put your credit card in and apply for a building, the clock would start, and within 28 days you had to provide your key building information. So the question was asked, why that's a disincentive to actually starting the application process. Surely that's nonsense. So a number of people, including myself, asked the regulator conference, and we got different responses back. Some people said, well, yes, of course you've got to do it within 28 days, but couldn't explain why. Others would say, well, no, that's ridiculous. We were involved in building the registration website and there's nothing in there that measures time. What it actually turns out is that it's very clear in the regulations that have been enacted by Parliament that yes, you do have to register register key building information within 28 days of registering your building with the regulator. We're now about 60 days beyond when you could have first registered, and there's still no way to actually provide the regulator with that information. So it leaves everybody, I think, in quite an unclear position as to exactly what is the legal position, because failure to register or comply with those regulations is a criminal offence, and that's what the regulator keeps telling us. So that's the first point. The second point is that in all of the government guidance, the registration window, it's always the principal accountable person has 6 months to register their building. To my mind, the end date, the close date is the 30th of September, so that's fixed. The registration didn't open until halfway through April, so that's 5.5 months. And now we're over 2 months into the 6-month registration window. You still can't finish your registration journey. So that's not 6 months. So again, another question that's been asked to DLUC and to the regulator is, will they be adding on the time that they've lost at the start of the process to the end date? So will they extend beyond October? The legal advice I've received so far is that that would not be possible legally to extend that window. But they are saying that everybody that hasn't done this by the 30th of September at midnight is committing a criminal offence. So we will come on a bit later, I think, to talk about enforcement, but it would be interesting to understand actually what they're going to do if 50, 60, 70% of buildings haven't been registered by the end of September. Over to you, regulator. What are you going to do next?
We have a hand up.
Yes, Scott.
Scott.
Hi, everyone.
Hi, Scott.
Hi. It was just a quick one. I actually spoke with a member of the Building Safety Regulator Friday before last. I had a one-to-one with them. And I brought up that question as well about key building information in particular, knowing that there is no specific space or way of adding that information within the portal, and when will that be ready. I won't try paraphrasing because I don't think that'll be fair on them or me, but in essence, the software vendors that are building that portal have obviously surpassed the deadlines to create that particular element of the portal for key building information. They're hopeful it will be up soon, but there's no particular date, and therefore, as you alluded to there as well, they couldn't actually change that law anyway. So they are hoping, in effect, more than anything, that the vendor can actually get that work in sooner rather than later and not prevent anyone from submitting. So even if it was 24 hours before the 31st of September, for instance, the portal will be open. They're hoping people will still have that information ready to submit at the time. So they're advising people to still pull it all together, and hopefully that portal will be open sooner rather than later to do it.
That's brilliant, Scott. Thank you for the update. I've got a supplementary question on that for you, if I can. Was there any discussion around clarification of exactly what that? So if I want to, for example, build a spreadsheet and answer all of those questions and get them ready, because I'm only going to have 24 hours to stick all the information in, it would be enormously helpful to actually know exactly how every single question is phrased and what all the supplementaries are down each branch, so that I can actually go in and say, I can answer that one, not applicable. That one's got to be a yes or no. That one's a percentage. So at the moment, the guidance is very much type of information we want, not how are we going to ask you that question. Was there any discussion about that?
Yes and no. It was more, yes, we did have that conversation. We've had that previously, but it's been more along the lines of the safety case previously, and what we think the information will be and what format we think it will be. Will there be more guidance? And they've always said all along, and I've seen on various different platforms as well, webinars and things, they're not going to be too prescriptive, and they're doing that intentionally. Now, with key building information, the difference there is obviously they have provided a very prescribed list within its own regulation itself with key building information. So obviously part of my role is to now design the portal for key building information in order for you to ask the same questions and provide all that information so it's ready to then submit in the one go. So as I'm doing that, and I'm creating the data templates based on those, I believe there's 18 different lines or requirements within key building information. I'm going into it now, breaking it down and thinking, actually, you could provide X for that and you hope that it responds in the correct manner, or you could provide Y. So there is some slightly grey areas there. But I do think key building information is more straightforward. But sorry, it doesn't really answer your question. What in terms of key building specifically, but what they are saying is beyond the guidance that's already out there. Yes, there's going to be more secondary, which was also telling when they said it could be either hopefully in the next 2 months, but potentially much longer. So they still don't really know when that's going. But I wouldn't sit back and hope there's going to be much clearer guidance on being too prescriptive, should we say, about what information should provide and in what formats, that type of thing. They're still keeping that fairly loose because, as I assumed, they are not entirely sure themselves what is best. So they're waiting for industry to come up with their interpretations, so then they can pick and choose what they think is the best way of doing it, and then perhaps be more prescriptive in the future based on best practice. I think that's probably the way that they're viewing it.
Marvellous, thank you, Scott. Mark.
No, I agree. It's not. I agree with you, Matt. It's not clear enough for me. I mean, as a building surveyor, when you say, what kind of roof is it and what kind of wall is it, and can you confirm what energy supply is it? To we can say, yeah, it's electric, yeah, it's gas, yeah, it's a flat roof, yeah, it's got a it's a warm deck, flat roof or whatever. But do they need something more? And I suppose I've been trying to advise clients on that the regulations, while they do add a little bit more meat on the bone with regards to the key building information. Obviously, people are going out there, having to go out there because the regulator is saying it, go out there now to obtain that information from every building. So they're asking for all these surveyors or whoever they're getting people to grab that information. And there needs to be an element of flexibility with that. So, I think clients just need to understand that potentially there is no prescriptive thing at the moment. It could get prescriptive, and therefore the level of information on that survey needs to be quite robust. And I suppose only clients can really tell about how far they go in terms of obtaining that information. I think taking loads of photos and taking lots of as much information as you can on the building in a coordinated way is going to stand you in good stead. they could still come back and ask for something that you know, if you stood left a little bit, the photo would have captured it or whatever. There's always going to be that risk, but I think the regulator will allow for elements of TBCs in that. I don't think they're going to come down hard by people saying, "Oh, we haven't quite got that. Can you give us a bit more time just to go away and clarify it further?" I think they're going to be more willing to help people out and clients out and give them a little bit more time, as long as everybody's just tried to make the effort and tried to do the right thing.
Yeah, I think it's one of the issues is that if you're in an information upload form and you can't move on, or you have to put an answer into a question, and because you didn't know that you needed to answer the question, you haven't got the data. Do you either make it up? So we've had this with initial registration for where you've in FSCR, where you're talking about what's the risk level of an external wall. That it's high at the moment, we think, and it's subjective, but then I can't go back and change it and all those sorts of things. That by having a formalized form, it's really helpful to know what are those contingent sort of downstream questions. So then if you've got people that, like Scott maybe sort of doing what we're doing, is sort of building a database structure behind it so you can capture that information at scale. You don't want to be rebuilding a database because suddenly the question set changes. So it's a really difficult one, but we probably need to move on from that. Scott's got a very good question. To answer Richard, we've got an hour and a half booked. Scott?
Yeah, thank you, Matt. It was, Mark just reminded me of another part of the conversation I had with the building safety regulator in terms of key building information. I did ask specifically about it, and what they said, they reminded me, and I'm sure everybody else knows on the call, what the use of key building information is for. This was based on my assumption that I asked them to clarify. I tell customers that the point of key building information is in order to inform the building safety regulator and two parts of their role. One is obviously they are there to make sure Grenfell doesn't happen again, and make buildings safer, and make sure this information is in place. Actually, the second part of their role is to make recommendations on how these legislations need to evolve going forward based on best practice and trends. So key building information is purely there to help create a data set, and it's a fairly basic data set. So when we spoke there about the roof types, for instance, they don't need to know anything more than it's either a flat roof, a pitched roof, or a bit of both, because all they're trying to do is create this data set of the 12,500 buildings that are out there, the HRBs, and get a basic understanding of what the form of these buildings are, to then create basic trends and patterns and things like that. So it's not like the safety case where obviously that has to go into more greater detail. This is basic key building information in that sense.
Cool. Thank you very much, Scott. Right, moving on. So the safety case regime, next key bit. I think what would be really useful, I think a lot has been said about safety cases and the need for them, whether they're overly complex or, in relation to a high risk building. And I think we've all got views on that. I've been quite clear about mine. Anyway, they are what they are. They are seem to be this bit of sort of a unicorn status around what is an acceptable safety case and what does the regulator want? Well, we want the industry to show us, and then the industry says, well, we want the regulator to show. And the net result of that is that there are probably nowhere near enough of these out there in relation to the 12,500 buildings that are probably going to need one. So what I want to do is quickly flip over to Emily as the specialist in this to give a very quick sort of run through of some of the common misnomers, if you like, or your interpretation of what's needed.
Thanks, Matt. So when or the work we've been doing so far, I think we talk about a shift in culture, and for me that's largely around the building industry that has been very much compliance focused. So if you think of these are Venn diagrams, if you think of two overlapping circles of compliant and safe, you can be, and you want to sit in the middle where they overlap, because you could be compliant, but you could still be unsafe believe it or not. I mean, Grenfell's probably a good example. They would argue for compliance. If you'd said, is that building safe? Well, clearly it wasn't. And somebody did ask the other day, they said, if Grenfell had had a safety case, would it have happened? And I think it's a really difficult question to answer, because you can still write a bad safety case. And it's about the data that goes into it. But what it does do is it forces the organization to ask those questions. So it's not just about compliance. And in fact, I was with a client the other day who was having a slight issue with their compliance manager. I won't name any names, clearly, but the compliance manager is saying, well, we're 90% on our EIRC checks. And he was saying, well, but we're not 90% safe on our EIRC checks. We're only 60%, because a percentage of those checks have come back saying they're unsatisfactory. So you might have done the check, which is the compliance tick box. Have you checked it? Yes, but the check is showing that there's a problem potentially. So in a safety case thinking, you can't then evidence that as being acceptable. So we sometimes, when we sit with people, we say, right, forget all about compliance, forget all about the law and everything. Convince me, imagine we're sitting in a pub over a glass of wine, convince me that that building is safe. Convince me you put your, everyone says granny, don't know why grannies. Would you let your children live in that building? Like, why? And so it's thinking a little bit broader than just, oh, because, we've ticked these compliance boxes. It's about, why is that cladding, why is it acceptable to have that cladding on the building? Because it might not be compliant, but equally it might not be flammable. So why is it okay? How do you know? How do you have confidence? And that's what a safety case, we have confidence in the cladding that there is not going to be a fire in the envelope of the building because of X, Y, and Z, whatever X, Y, and Z is. And then you have to evidence that. It has to be valid, relevant evidence. We're confident in our stay put strategy because of X, Y, and Z. We're confident that the fire doors are going to, help with our compartmentation because of this. And again, some of those things may not be compliance. If Matt will have heard me this morning talking to somebody about, they had a fire, the fire went out the window, was around the outside of the building or around the outside of that flat, and the cladding didn't burn. They were able to put the fire out, no spread. It's like, well, that is part of your evidence to show you that cladding, you're saying it's safe, or it's it's not flammable. Well, there you go. There's a picture of that thing on fire that isn't actually burning. I'm not suggesting you burn your buildings to check whether they're going to burn, but it's about building up that evidence and your legal case. And if you think how a barrister would do that in court, they're going to pull every bit of evidence they possibly can to prove your innocence. And it's the same with a safety case. And it's trying to develop that thinking, which is beyond just a compliance mindset, is probably where I'd go with it. Happy to take any thoughts or questions, or if anybody disagrees with that perspective. And also, the other thing I was going to say, which I like to stress, is that the regulation, I'm just going to pull it up here so I can read what it says. It says safety cases and the information and evidence that supports them must be kept up to date. They are not one-off exercises or only to be revisited when an application for a building assessment certificate is required, which means this is not a report. A safety case and a safety case report are two separate things. Obviously they're linked, but you could have a safety case report without a safety case, because the report is a snapshot in time at that moment of what's happening in your building. The safety case has to be kept live. People have to interact with it continually. And that's when you want to send something to the regulator, you hit print, there's my report. But that's my report that's valid at that moment. And then it's potentially invalid. So the report and the safety case, obviously, they interact, but the report is not a safety case.
I think that's a key point, Emily. Thanks for that. On looking forward, so there's a lot of discussion at the moment around the commencement date on the 1st of October, and then the magical April 2024 for safety cases. So the inference is, well, I only need a safety case from April 2024.
Sorry, Matt, to interrupt. Sorry, Matt. I'm really sorry to interrupt you. I just wanted to respond to Simon's comment saying the safety case report is a summary. What did he say? Of the safety case. Yeah, absolutely. It's a summary of your safety case. But what I'm seeing is people writing a report or getting a big consultancy to write them a report in Word or whatever. And then that is saying, this is my safety case.
Yeah.
And I would argue that that isn't. Sorry, Matt. No. Carry on.
So, but it relates to that point that if, for example, your building gets called forward 2 years after April 2024, for example, I think from the description you've given there is the regulator would be within their rights to say, please prove that your safety case is living and breathing and continuously evolving, in which case you would expect to see some change between the 2-year-old version 1 safety case report and the one that you're now going to provide to the regulator. So we'll talk about enforcement in a minute, but whether they do or they don't, the reality is all of your higher risk buildings should, subject to registration, should have something that looks and smells like a safety case from the 1st of October this year. Okay, in the normal scheme of things, it is not planned for the regulator to call that safety case report in for assessment until April 2024, but legally you're required to have one from the 1st of October. So will they ask, if they call you in April, will they ask to look at October's version as well? Probably not, who knows. If in December 2023 you have a massive fire in one of your high-rise buildings and a number of people perish, might the regulator ask to see your safety case report that prevails at the time of the fire? I would argue that if I was the regulator or investigating, I would certainly ask, because legally you have to have one. That's the law. So I think there is I think at the moment a prevailing sort of attitude, that came from the pilot group, which is for any given organisation, let's focus on writing one safety case report. Not let's get a safety case in place, even if it's quite basic, for all 200 of the buildings in our portfolio. So there's a very acute ticking clock in relation to having something that you could hold up and offer up as a safety case, should you need it, and then how that's then iterated and improved over time. So I think BSA mentioned a building safety case report, but not a building safety case. The safety case is not explicitly mandated. I think we might go down. We could take that one offline, I think, Simon. But it's which came first, chicken and the egg? Because the report is meant to be an exec summary, effectively, of the broader safety case, which includes all of the evidence and file. How do you normally write an exec summary as a summary of a much broader report? You don't write the summary without the report. So, and I'm using the report in the wrong sense, but that's the difference.
So Matt, I won't go down the rabbit hole.
Yeah.
I'll try not to. But it is, so Simon, you're right. This is something that people are struggling with because I don't think it's very clearly worded by the regulator. And if you look at the consultation that happened in January, they talk about, so I've just got it here, part of the new regulatory requirements, we're introducing a safety case regime. Now, I've worked in a safety case regime and I know what that means. Then there is a lot of reference to the safety case report, and they almost use the two things interchangeably, which really doesn't help anybody. And I think that the regulator is creating problems by being slightly ambiguous. I would interpret a safety case regime as one in which you have a live, ongoing safety case, and periodically you will create a report from that. That's my experience of a safety case regime. Anyway, thanks for the comments.
We'll move on. These things will come out in the wash, but on the basis that 12,500 times people are meant to be producing these by October, this level of kind of ambiguity is not helpful to anyone. Another key theme, golden thread. Again, huge variation in what this means. My simple way of looking at it is keep hold of everything that might be pertinent to this building. Keep an eye on or keep evidence of your decision making. You know, keep it as data. It doesn't necessarily mean you need to go and buy software that does absolutely everything that this regime might need now or in the future in one place for one monthly fee. That doesn't exist. What it does mean is if I want to dive into your safety case, a golden thread should be a part of it. And when I ask you a question about something, you need to be able to show me that as data. And then when I say, how did you make that decision? I would like to also see a record of how you came to that decision in broad terms. It needs to be portable, so we don't get the whole sort of cliff edge, private high-rise building changes managing agent every 3 years or whatever. And every time you get to the end of that 3 year, any data that did exist about that building suddenly falls away or gets held to ransom and everyone starts again. So we want to see a contiguous history of that building through its life cycle as data. Again, and the regulator and the government, you know, or the government really in legislation has, I think, really thrown the industry under the bus here in terms of pushing all of this responsibility down to the industry with very little guidance. It would be, to my mind, as though rather than having a single database of car registration and VIN numbers in the UK, we've got the Volkswagen registration database, the BMW one, the Vauxhall one, and then to say, oh well, if that Vauxhall gets sold to a BMW, whatever, or they merge, then they'll just magically make it all happen. The government really should be offering the supercomputer, if you like, that all of our software providers, we sync key information into that sort of definitive golden thread. But we could take all day talking about that. So the key thing there is a lot of things we see from clients is, well, I want a golden thread piece of software that does absolutely everything for me. When you consider everything from writing your claims arguments and evidence for a safety case through evidential building level documentation right down into granular asset information and movements and changes within all of those environments and interaction and interoperability, etc., and then portability, I think it's unrealistic for anybody to have a single way of managing that entire process, bearing in mind the regulator can't even agree what the process is yet. So it's subject to change. So I think keeping it as simple as you possibly can is good. Yeah, absolutely have granular information about your building. Where are things on a plan? Can I do counts of fire doors, etc., etc.? But don't also try and produce your safety case reports from the same piece of software, because the likelihood is you're going to come up short everywhere and you're going to end up with a mess. And expect that those solutions are going to evolve over time, and this will settle down over time, and you may well end up replatforming as time goes on and as vendors can get around these issues and they bed in. Very quick question from Jan.
Yeah, yes, it's just that we're running out of time, and Deepa's been sitting there very patiently, and I'm just curious to know whether, as a resident, whether she's in a block that is affected by whether her building is in scope, because I'm very interested in the resident engagement strategy stuff, which is kind of the add-on to all of this that nobody seems to have done a great deal of. I haven't seen a great deal about, and I'm just wondering, since she's said so far that there's nobody been in touch with her at all. First of all, is she in a property that is affected by this in scope stuff? Is the question. And has she had any involvement with anybody within her housing association, whoever it is, about it so far?
My building is in scope. I'm in a high rise. It's 7 stories.
Okay.
It did have some cladding issues and some fire safety issues, but this was all remediated, so it's all done and it has been signed off. We have now an EWS certification. Have I had any communication? It's not really anything more than a letter, always with, it's an open letter to say, if you do need more information, do please contact us, but there's never been any phone calls or any meetings. And I value a face-to-face conversation, because my experience has always been, I need to call and I need to leave a message with a call center, and then I get a call back and I don't hear back for days, and by that time it's relevant. I do just prefer a face-to-face, and that hasn't been done, and it hasn't been done for years now.
Sorry, Deepa. So, and who is the housing association? Are you prepared to tell us?
I think it's best that I don't.
Oh, go on. No,
It's
No,
one
no,
of
we're
the-
good. Yeah.
Go
It's got our
on.
brand on it. I don't want to get sued, Jan.
Oh, for goodness!
so-
No, you're not going to get sued for somebody not doing something if it's not. If it's not.
It's a very
But-
big one.
But I do have a good example here as well. So when the building was being remediated, no, we were not we were not interacted or communicated with from the housing association. However, the contractor on site made sure that there was a touch point person that
Good.
you could just, you could go and knock on their door and have a conversation with them. So at any point in their works, you could go and speak to them. But
Good.
that shouldn't have been the case. It should all go through the housing association, because I am their customer and the contractor is their supplier. That's how I feel anyway. But
That's fine. But having a resident liaison person for a piece of work like that would be normal practice, and I'm pleased to know that the contractor did it. So that's one tick in the box. The other box is
the
clear.
contractor only did it because we raised complaints after about 4 weeks of not being spoken to. So
Okay, I'll shut up. All right.
I mean, it's probably something that, resident engagement is a whole subject in its own right that we probably need to talk about, and happy to
But-
put
but
something on where we can go into more detail.
No, absolutely.
I think the key point on resident engagement I was going to raise is that, to my understanding of it, it should be a two-way dialogue, not just we're going to shove stuff through your letterbox and ignore you. It's about partnership working. But similarly, I also understand that when you're being asked very detailed questions by residents, quite rightly, if you're effectively saying, well, the regulator doesn't even know what they want yet, I can't really definitively answer your question, that does put you in a difficult position. So there's an element there of not making excuses for it, but these things will bed in, but the behaviours should be entrenched by now in terms of communication on a human level. So that's a good thing. Just a point, because we are running out of time, on enforcement. So powers from the 1st of October, obviously we've had the Gateway 1 powers since August, a couple of years ago. But when it comes to in occupation from the 1st of October, there is a lot of, you will be, do this or do that, and you're committing a criminal offence. There's even in the registration portal, go any further, committing criminal offence, etc., etc. Will the regulator have the wherewithal to enforce in terms of staffing? Don't know. I mean, they're struggling, I think, to get enough people on board. But I think the way I look at it is that they have the legal powers. They don't have a legal duty to be a really fantastic regulator that's really efficient at regulating an industry. They might get a telling off, they've got a license, but give them enough provocation and enough evidence and they can enforce against you. And I would imagine that they will. Peter Baker, prior to his departure, did say that they are looking forward to baring their teeth effectively. Obviously not looking forward to it enough to stay in post, but that's probably another debate. So I think they can, and they probably might. Will they? We don't know. Back to my point at the start, if you've got 12,500 people who you don't know that are meant to be doing something by a certain date in time that they can't quite do yet, what are you going to do to enforce against them if there's only 4,000 registered buildings at the end of September? Are they going to have an elite unit of 8 people to find 8,500 PAPs and hit them with a fine? Who knows? But I would suggest it's probably not worth being in that group and testing their mettle at that point. Moving on very quickly, just want to give some final thoughts and we'll have some final questions. So what would I be doing? One, I would be thinking, how do I tick as many of these sort of regulatory compliance boxes as quickly as I can for the least amount of money to give myself some defensibility regardless of what the regulator does. So one thing I would be doing, and we're just about to roll out with a new version of the Building Safety Register, is a dual registration environment for both the Fire Safety England regs and the Building Safety Act. From a Fire Safety England regs perspective, what it does is it gives you a consistent view across all 43 fire and rescue services of your pertinent information and your fault reporting. On the Building Safety Act side of things, once we can pin down the question set, it gives you the opportunity, again, in one view, to go in and see your 100 buildings in a tabular view and jump in and out of them, uploading key building information, so that when you get to 100%, you're then ready to go in once into the regulator system put all those values in, answer all the questions and hit submit, which is a fire and forget. So at the moment, what we're finding is that people are having to manually log into individual buildings in and out all of the time to go and update parts of their information. So again, but it does rely in a sense, and why we haven't put it live yet is trying to pin down as far as possible that the question set in this environment completely mirrors the one that's going to be rolled out by the regulator. And give you sort of percentage completes and all those sorts of things, because actually gathering all of this information, most people at the moment are gathering this in a spreadsheet, and it's subject to all sorts of problems and you know, missing rows and not being configured in the right way, and it gets pretty unwieldy pretty quickly. So that's something that we're doing. Again, you know, we're looking at pricing that about £2 per building per month or something, just as we're covering a bit of cost perspective to help everybody. And then it will link into other things going forward. Behind the scenes, we're lobbying with both the fire services and the regulator to say, we would like you to receive this information as data directly from our database, rather than somebody having to copy and paste all the values across. So that's ongoing at the moment, but they're fairly close to that way of thinking. When it's evidence for the golden thread, again, our product, you can do it anywhere, but we do it pretty well, which is about your documentary evidence around each of your buildings for golden thread sort of documentation information. That's what we do with Track My Risks in structured environments that are intelligent and remind you when to take action. I will send these slides out, so if anybody wants to click through and have a play or get a demo or whatever, then please give me a shout. And then the other thing is to start spinning up your safety cases. I would plug Emily and Risk Flag as being the only platform that I've seen at the moment that you can create these environments and then render your reports at the push of a button in real time to a structure that you agree, and it does a lot more than that. And Risk Flag can talk to Track My Risk to pull its evidence in and cross compare evidence. It's not to say this is the only way to solve this problem, but that's how we do it. So I think feel free, but there are other people out there that do things as well. And I think the key thing, the takeaway, regardless of who you do it with, even if you're using spreadsheets and SharePoint environments or whatever it is really need to get on with it. If you've got 1 or 2 safety cases emerging at the moment, you've got another 98 buildings that you haven't started yet, please start them. The good starting point is gathering your key building information, because to gather that you will have to pull together or commission a lot of the evidence that you'll need for your safety case anyway. So start building that up, and if you can write down all of your, or keep a record of all of your decision making wherever possible, again, that's really going to help you should you fall under the glaring eye of the regulator going forward. Yes, Des, I'll put the slides out. Scott, the consequences, I think if you mean the criminal consequences, I think it's the tariff for fines, but 2 years in prison, I think, is the max from memory. Might have got that wrong. Dean, yes, I can sort out a demo. We haven't put the production version live yet, but I can certainly show you that on a demo. So I will ping you an email afterwards to set up a conversation. And anyone else that wants a demo, just send me the details. My information's there, but you'll get that in the slides anyway. We're 1 minute over, but are there any very quick questions at the end? Or are we all good? Excellent. We'll send you a link with the recording if anybody wants it, and you know how to get hold of us by email or just hit me up on Google. And if there's anything else that you want us to do another panel show about, it sounds like resident engagement might be an interesting one to take a swing at very soon. So give me a shout. But thank you very much, everyone. Take care.
Everybody.
Thanks very much. Brilliant session.
Thanks, mate.
Thank you.
Thanks. Bye. Bye.